question that I'm commonly asked is, how do you go to court to get power of attorney over somebody? And the question in and of itself shows the lack of understanding that most people have about a power of attorney. A power of attorney is not something they go to court for. Rather, if someone wants you to be their power of attorney, then they have a document drawn up, typically by an attorney, that appoints a particular person to be in charge of their finances or of their health care. In the case of finances, you would choose who is in charge of your finances, and that person can actually serve as your power of attorney while you're healthy and can also continue to serve even after you're no longer healthy. Or you can choose that power only takes effect once a doctor says that you're not able to make your own decisions, then only then would the power of attorney take effect. But in such a case, and in all cases of power of attorney, the person appointing you as power of attorney, the person granting you that power, must be competent and able to make that decision while they're still healthy and while they're still able to make decisions. If they wait until they're no longer able to make that decision, well, then you will have to go to court in order to obtain what's called a guardianship, and that's a much, much more difficult process. So this applies for financial decisions, and then typically there's a separate document that's drawn up, similar concept, but for healthcare decisions. Now, the healthcare power of attorney for healthcare decisions only takes effect when the person writing it is no longer able to make decisions. Because if that person can make their own healthcare decisions, well, then their personal autonomy demands that they make that decision for themselves, and only in the case where they actually are no longer able to make decisions will that paper that's called the healthcare power of attorney actually be implemented.